So, quick review about Craig versus Boren. What exactly it did? It opened up third-party cases, so the third party could stand in for anyone else. Made intermediate level of scrutiny for sex discrimination cases, the 21st Amendment, and helped this thing called the Equal Rights Amendment. The Equal Rights Amendment started in the 20s, and it was this movement. Basically, the amendment said that men and women are equal, and this would have been in the Constitution. However, it doesn't exist because the state's not ratified it. However, part of this is because my case, Craig versus Boren, it basically stood in for the Equal Rights Amendment, and so it would have given the sexes equal power. Other things that, well, it would have helped things like my case, which discriminated against men, and also would affect sex discrimination in insurance, Social Security, and pensions, where women are penalized because of their gender and positions in society as homemakers and caregivers. So it's really that Equal Rights Amendment, like I said, it's not in the Constitution, but my case stands in for that. And that gives it a lot of power because it sets everyone in here, based on sexes, as equal, 50-50. So it's pretty awesome. I'm going to stop there.
Okay, I'll start with a brief summation of my case, just to remind you guys. My case is Griswold v. Connecticut. It started out in 1965 with two Planned Parenthood workers. They were sued by the state of Connecticut under a statute that said strictly any use of contraceptives or any person who assists, or any person who uses any drug, medicinal article, or instrument for the purposes of preventing contraceptives shall be fined not less than $40 or imprisoned for not less than 60 days. Now, these two workers for Planned Parenthood had advised married couples on what contraceptives to use, and so under another statute that says any person who assists, abets, counsels, causes, hires, or commands another to commit any offense may be prosecuted and punished as if he were the principal offender, so they were fined $100. So they appealed to the United States Supreme Court because of this, because they thought it violated their right to, both their right to privacy. So first of all, there are four major things that the 7-2 decision in favor of Griswold did. First of all, it developed stricter guidelines for what is the state's ability to protect health and the safety of the public, which is what Connecticut had defended their statute under. Obviously, the use of contraceptives was not under the ability for them to protect the health and the safety of the public, but others might so just develop better guidelines for that. Secondly, it overturned tyrannical law and set precedent for other laws that may restrict public's rights even beyond the right to privacy. For example, it extends and defends the rights of people to use contraceptives, obviously, and then other public safety, health and safety laws. Thirdly, it extends court powers. It expands the court powers and their ability for the court to create and justify these penumbras that they find in the Constitution through different bills, or through different amendments in the Constitution, or in the Bill of Rights that defend rights. Together they can combine these and create another right that is inferred but basically enumerated. And then fourthly, it defends the right to privacy, which is the most important.
Okay, so I will say that in this case, the concurring opinions there, so there's dark and murky swamp. The justices all had different concurring opinions, and there was no mandate. Furthermore, with Griswold, it didn't really legalize birth control because there are already methods of birth control that were there. There's the rhythm method, there's and also, last but not least, quick reflexes. Also, as I said, it only affected married couples who wanted to use methods of unnatural birth control. As he said, it gave judicial branch more power, but it would give it too much power as putting as legislative power as well as judicial. And also, it didn't technically it supported the right to privacy, but it also belonged to the right to privacy. So did, according to our internet research, at least 12 other cases helped do this.
Oh, I'm sorry.
Okay, I'll start out by saying why Craig v. Boren did not matter at all. Okay, it dealt with equal rights. Basically, there were so many other bills and cases that had already defended equal rights. It was mainly for races, but you can find plenty of bills that defend equal rights for men and women. Brown v. Board, the Civil Rights Act of 1964, those are obvious cases where rights between the sexes are defended. Now I'll address some of his attacks. First of all, they're contraceptives, not birth control, so it's not really pulling out the... also... Whoa! Okay. So he said that it only established the right to privacy for married couples. It established the precedent of right to privacy. Other cases had talked about right to privacy, but none of them had defended it with all the amendments in the Bill of Rights in order to create this penumbra of right to privacy, which is now justified through the Constitution and constitutionally backed. So this was the first one that actually guarantees your right to privacy.
How many of you thought Forrest in his defense of Craig v. Boren was more persuasive?
Stupidest case ever.
Yeah.
Raise my hand. I demand that you raise your hand. Raise your hand.
And for Avery. Okay, the class votes for Forrest because he talks about the rhythm.
That was not my vote.
Not mine.
All right, Senator Hensley.
Here's my answer. Needed to ask a question. What Well, that is the rhythm method.
Well, no, the rhythm method is based on menstrual systems.
Yeah.
Cycles.
Like the calendar for it.
I too am going to go with Griswold.
I think that was fake.
People's choice.
Dang it, that would have been the best round.
And Forrest had quicker reflexes, he would have had a better Supreme Court case.